Welcome to today's segment of The Power of Money. I'm your host, Michelle Graves, nationally known as the Money Lady. And as always, I'm delighted to be in your world for the next hour. We have an awesome show today, and for those of you who are not familiar with the complex world of estate planning, makes you feel a little nervous because you don't understand. I'm getting ready to open that whole world up for you so that you can begin to act proactively in your own personal financial life. I'm delighted to have today, for this segment on understanding estate planning, a very special guest, and that is Michael J. Millonig, who is based out of Dayton, Ohio, is a licensed attorney. But listen to his credentialing because it is so important. And I say this, and I've said this over the years to clients, that it's important for you to engage the services of a credentialed specialist. And so I'm going to share with you a little bit about Michael J. Millonig, attorney at law. He is a Ohio State Bar Association board certified estate planning, trust, and probate specialist. He is certified, and this is so important, viewers, as an estate law attorney by the National Estate Elder Law Foundation since 1998. That's a long time. He is CPA in active status. He is a VA accredited attorney. His professional memberships include the Ohio State Bar Association, Elder Law, Estate Planning, Trust and Probate Law, and Corporate Counsel. With the Ohio State Bar Association, he was the Elder Law Chairperson from 2008 until 2010. With the Dayton Bar Association, again, he's the Estate Planning, Trust and Probate Law Committee. He chaired that committee from 1999 to 2000. He has been a member of the National Academy of Elder Law Attorneys since 1991, and I will close out by saying that he is listed in Ohio Super Lawyer's Guide to the Best Lawyers in Ohio. So without further ado, I'd like to introduce all of you to this absolutely amazing gentleman that I have the pleasure of knowing and working with, attorney at law, Michael J. Millonig.
Okay, thank you very much for that introduction.
Good to have you here today.
Thank you. Thank you.
Let's talk about, over this next period, the whole area of estate planning. And where would you like to begin?
Well, I mean, we can just talk about the basic. A quick overview of estate planning generally involves doing your will.
Okay.
A power of attorney.
What is a will? Let's go back to that.
All right.
Okay. What is a will?
A will is your document that says, states your wishes on when you pass away, who gets your property, basically.
Okay. And does it take an attorney to prepare a will? Because we hear so much of this out here today, where computer wills and all these other organizations.
Sure, yeah, that's a good general question. I mean, like anything else in life, you could do things yourself.
Yes.
So I can't say you can't do your own will, and you can certainly find forums on the internet, but what a lawyer does is two things. One, it does prepare and draft the will, but more importantly, advises you on certain things related to the will, and the lawyer obviously has experience drafting wills and understands the law, and so certainly could do a better job.
Then, because the laws vary from state to state, is that?
Oh yes, definitely. If you go, if you go online and get some kind of will form, if it's not specific to Ohio, it may or may not have the right things in it.
The language would be
Right.
a little bit different.
Right.
So you can do your own, do it yourself, but it is not advisable.
No, certainly not. No.
Okay, that's important.
Yeah.
What is estate planning?
Estate planning involves just planning for what happens if I pass away, and also really what happens if I become disabled during my lifetime. Those two things.
So it's not just dying, but it's also if you're disabled during your lifetime. That's a
Right.
part of the estate planning
Correct.
model as well.
Right.
Okay.
Right.
Why do you think, and we don't want to, I don't want to pause because we're talking about wills. But why do you think people don't do estate planning?
Well, because we don't like to think about dying. I mean, it's not a pleasant thing to think about, and it's a very easy thing to put off, especially when you're younger. I do notice people when they retire and they're in their 60s, they think more about it. But of course, any of us could pass away at any time. So.
Because I know statistically, I have read that the majority of people die without a will.
Yes, yeah.
Known as intestate.
Correct. Correct.
And exactly what happens when they don't have a will.
If you don't have a will, Ohio law, as every other state, has basically your own will for you. It has a list of who will inherit everything. So it basically kind of goes down your family tree. It starts with if you're married, it goes to your spouse.
100% would go to your spouse if you die.
Yes.
Okay.
And then if not, no spouse, then children, and then so on. So, and if you don't have a spouse or children, it goes to your parents, and then back down your family tree. And let me correct that for a second. Now, if you do have children, spouse, the children could inherit some of that.
Could they?
So, yeah. And there's a little more complicated scheme. The spouse is entitled to an allowance and some other things. So, but the point is, you don't want to rely on that. It's very simple to just go do a will.
Do you think people are intimidated by cost, perhaps?
I don't think so, and I don't want to talk about fees here today.
Right.
But most lawyers don't charge that much.
I didn't think they did.
It's not that expensive.
Yeah.
But you're right. People probably are concerned about it, but it doesn't hurt to look into it.
But it's going to be more costly if you die without a will, correct?
It definitely. I mean, I handle estates without wills, and it's a lot more work. There's just a lot more things we have to do, and there's just some simple things that the will does that saves a lot of time.
Okay. So it starts when we look at an overview of estate planning, which is ordering your financial affairs in anticipation of death or disability. Is that a fair definition?
Yes.
Okay. So it's that ordering, and the first step is the will.
Yes.
Correct?
Right.
And what is your second step?
The second step is the what I call a general power of attorney or financial power of attorney.
Well, can you speak on that?
Yeah. Let me put it this way. If you don't have one of those, if you become physically or really mentally disabled, and you're not able to sign checks and take care of paying your bills, someone would have to go to court to be appointed your guardian. And that's kind of a lot of trouble. You have to, you have to be declared incompetent, and you have to report to the court every year, and there's attorney fees. You can avoid all that with a simple power of attorney where you give someone the power to pay your bills and basically sign your name to any legal document. So.
That brings up, because both of us have been in the industry a long time, you on the legal side, Mai on the advisory side. You spoke of a power of attorney, and there's a general power of attorney, but then you can have specialty powers of attorneys, like the financial management, where a person only handles one aspect?
Well, you can have a limited power of attorney.
Okay.
It's pretty rare that I would ever do that in estate planning. If we're doing estate planning, we want to cover everything, we would just do a general power of attorney. There's no point having a limited power of attorney.
Okay. Now, as a general power of attorney, would that encompass a durable power of attorney?
Well, it's also called a durable power of attorney. The term durable just means, many years ago the law used to be different, but now the term durable just means that when you become incompetent, the document's still valid.
So let's play this out, because in many situations, you have to name someone who would act as your power of attorney, correct? Do you run into situations where families are kind of conflicted about who gets named?
Well, when I talk to a client, I say, look, here's the things you want to, I explain what I already explained about having a power of attorney. I say, you want to choose someone who is trustworthy, someone who is responsible and can take care of your affairs, someone who has time to do it and is willing to do it. And then I tell the client, well, obviously I don't know your family. You know your family best. Who's the best person? So it's up to them to choose. Now, some people don't, maybe they don't have children or they don't have people close. And every once in a while I run into someone who really doesn't have anybody they feel comfortable with. And so I
what
say,
do you recommend?
Well, I say, well, then you don't have to have a power of attorney. We don't want to appoint somebody that you don't absolutely trust. You have to absolutely trust them. And if you don't have anybody like that, then fine, you don't appoint anybody. And if someone has to be your guardian, that's fine. It's not that big of a deal.
That's tough, though, Mike. I mean,
what do you mean?
When I
why is
say
that
that,
tough?
when they don't have anybody
Mm-hmm.
and their situation becomes, they become ill and are not able to handle their affairs.
Mm-hmm.
So who handles their affairs?
Well, that's a big problem, really. Yeah, right. Some people really don't have any
They
close
really
family
don't
members.
have anybody.
Somehow, someone has to step forward, and a lot of times, if someone's in a nursing home or somewhere,
Mm-hmm.
they're going to try to initiate something, and sometimes the probate court can find a local attorney who will volunteer to do that.
Okay.
So,
Okay. So then it becomes a court
yeah,
matter.
it's up to the court. Well, the court doesn't have to, but the court will try to find somebody.
Okay, to help
Yeah.
them.
Yes.
That would seem to be a very, very special type of a responsibility, because under a POA, that person is in fact you, correct? With the power of attorney, if a person becomes incapacitated, that individual who's acting as a POA has the authority to do a number of things, correct?
Well, when we say you, I think what you're saying
I mean,
is
the-
that they step into the shoes
they
of the
step
person
in the
appointed,
shoes
right?
of the person
yeah, you can do
appointed.
assign their name to anything, and so they have a fiduciary responsibility, which is a very high standard in the law, to do what is
Yes.
always best for that person. So, and what is best is not selling the person's car to your grandson for half price and things like that. So you have to always do what's best for that person.
Okay.
Right.
So from your experience, would you recommend that those who are watching this program right now, if they don't have that document, because so many people that have sat down in front of me, they have their will, but they don't have that, that power of attorney. So what would you recommend in a situation
Well,
like that? They go back to the attorney?
Yeah, they need to go to their estate planning attorney and say, maybe we better look into a power of attorney. And I'll tell you, of all the things we do in estate planning, that's probably the one thing that'll save you more money than anything, because that simple document saves you all this trouble of having a guardianship. And of course, if you don't, if you wait until something happens and then you're not competent anymore, it's too late to do it.
Right, I was going to
So,
say
yeah.
you cannot, if you've got out, you have no standing
Right.
to try to execute that kind of an instrument, correct?
Right, correct.
Yeah,
Right.
that's
Yeah.
what I thought. So I would think that that document is probably, in terms of importance, as important as a will.
Yes, I think so. Yes,
Okay.
yes.
As we look at, so continue. We now
Okay,
have
okay.
we have the will.
Mm-hmm.
We have the power of attorney, your general power of attorney.
Okay.
And that gives an individual the right to handle the financial affairs and other things as if he were that person or she were that person.
Yes.
And what's the third thing?
The next thing is the healthcare power of attorney. It's the same idea, but it's appointing somebody to make a medical decision for you if you're not able to. So it only applies if you're, you could just be temporarily unconscious or permanently incapacitated, but that person can make just kind of a routine decision, admitting you to the hospital, surgery, other medical care.
Now, do hospitals ask for that instrument?
Yeah, they have to. Federal
okay.
law requires them, when you go in the hospital, they have to ask you if you have a health care power of attorney and living will. You don't
Okay.
necessarily have to have one, but they ask
gonna
you that.
ask you that.
And obviously it's better if you do.
And the reason they ask that is because the federal government requires that requirement that you
Yeah,
ask.
I'm sure that's why they don't ask you if you have a general power of attorney
No,
or
they
will or a
don't, no.
trust, but they do ask you those two things.
Right. So the health care instrument is essentially empowers an individual that you name to act in your best interest in health-related matters.
Yes.
Okay.
Yes.
And does that go as far as impending death, or is that another instrument?
Okay, the next thing is what's called the living will.
Okay.
But before I get to that, let me mention something about HIPAA. A lot of
Okay.
people have probably heard of HIPAA. That's the federal government regulation with protecting privacy rights with medical records. And it's, from the point of view of the medical providers, it's a really kind of gotten to be a big thing in there. They're very afraid, because there's criminal penalties for violating it.
Oh,
so they're
really?
Yeah, they're very afraid of violating it. So what's important, just because you have a health care power of attorney, that person doesn't necessarily have the right to get your records, or we could be in kind of a gray area where where you're maybe you're competent or maybe you aren't. And so what I always do, and what attorneys should be doing too, is I do a separate HIPAA release form where the form refers, whoever you appoint under the healthcare power of attorney
Right.
is also part of the HIPAA release, so they can get medical records in any circumstance. And I do a general form, but I also tell people when we're signing it, I say, now, I'd suggest the next time you go to your doctor's office, just ask them if they have a HIPAA release form and fill that out there also.
So would a hospital have a HIPAA release form?
Hospitals would also do that.
Okay.
I do mention that to people, but of course a lot of times when you're entering the hospital, you're unconscious or something, you're not able to sign one at that time.
Right.
So we want to do things as much as we can ahead of time.
So this HIPAA, this is interesting because I must tell you, I did not know this. So this is good. I'm glad I had you on the show. With that particular instrument, that is good in all states, in every state in the United States?
The HIPAA release is a general, it's not related to state law, really.
Okay,
correct.
it's not, it's a federal law.
Right,
And it authorizes the person who you name to be able to access records and other information.
Yes.
Okay, that's very important. I would think so with most people. And that is complementary to the health care?
The healthcare power of attorney.
Right.
And the reason I bring it up too is because there have been kind of some horror stories, things about after HIPAA came out, someone calls the hospital and they heard their son was in an accident.
Right.
And they say, I'm sorry, we can't release any information to you. So, and that probably doesn't happen most of the time, but there have been stories about that. It could happen, right?
It could happen
Right.
because without that document, they would not be in federal compliance.
Correct.
What was the basis of that regulation? I mean, did something happen to some congressman's child that required this kind of an instrument? Because it would seem to me that a health care, at the point you've shown that you've tried to be legally compliant, and now you have another layer of requirement to be able to deal with your loved one.
Well, and most of the time, the healthcare power of attorney should be good enough to get those records, but we're just trying to be safe
The
in
second
case,
level of protection.
in case we want to make sure we don't get blocked from that person getting medical information.
Well, let me say this to my mother. I didn't know this. So we're going to have to do that when I get back with you. Because I didn't know that.
Yeah, that's kind of a new thing in the last few years. That's in estate planning. That's something that a lot of attorneys are doing now or should be doing.
Okay, all right. Well, let's take it to the next level.
Okay.
So we've got our health care, we've got our HIPAA document, and so what is the next
Then the
step?
next thing is for the more extreme case, if you're in a vegetative state, you're a vegetable, and you're on life support, you're unconscious, you're never going to regain consciousness. The living will then state your intention on what you want to do. I mean, most people say, I do not want to be kept alive in that circumstance. And so that's the living will. So.
And lacking a living will, what happens?
Well, potentially, worst case scenario is you could just be stuck there and nobody can have you disconnected unless you get a court order or something like that.
Okay. So
And those were some of the more recent cases, the Shivo case in
Oh, I
Florida.
remember that.
And there were
Yes.
younger women in their 30s who didn't have a living will, and there was a dispute among the family, because that's underlying all these things. The important thing in estate planning is we don't want to have disputes. We want everything to go smoothly
In an
for
orderly
people. So
way.
that's why we do all these things.
So the living will is necessary if an individual is in a terminal state, correct?
Terminal, they call it permanently unconscious or vegetative or terminal, but also you could be in a terminal condition, but if you're still mentally alert, then you don't need a living will. You
can
say whatever you
exercise
want.
discretion on
Right,
your own.
right,
Okay,
right.
all right. That's and that is not the same as a power of attorney.
Correct. Yeah, the living will is really your statement, which is strictly speaking, the law says that's controlling over whatever the power of attorney might decide.
Okay.
Right.
That's important. So that document supersedes whatever instructions were in the power of attorney.
Correct.
Okay, with regard to the terminal condition of that individual.
That's right. That's right.
And it only plays or has force in a hospital setting, or is it an automobile crash?
Oh, it
or
could be anywhere. Well, I mean, the typical setting is someone is going to be in an institution, hospital or nursing home, typically, but it could apply anywhere. I mean, it could apply, a person could have had many heart attacks, but still be living at home, and they may want to say, look, if something happens to me, just, I don't want CPR, let me go. So the living will could apply to that. Now, what's also important for that person especially, there's what's called a do not resuscitate order, a DNR order, and that's different than a living will. It's a more formal order that a lawyer wouldn't do. It'd be from the doctor. So if you're in a hospital or a nursing home, they'll ask you about that, and they will, if you want, they will put you talk to your doctor, and then they put a DNR order on.
So let me play this out as it could occur, and that is if a person has Alzheimer, advanced Alzheimer, and they don't have not much in the area of cognitive abilities, and who exercises the authorization for a DNR under that?
Whoever, if they have a healthcare power of attorney, whoever has that appointment.
Okay,
yes.
I got it.
Yeah.
Okay, because the thought would be, if they're not able or competent, then how does that flow in terms of who has authority?
The person with a healthcare power of attorney.
Okay.
And I wanted to finish up too. I was talking about that person who is not in a hospital, who's at home, but they don't want to be resuscitated. Okay. You get a DNR bracelet, which you can put like around your wrist or your neck is better. In fact, I read an instance where some woman had a tattoo on her chest that DNR.
Really?
So that's in the law. It's called a DNR identification. So for someone who's in the community who wants a DNR, you want to have that, because if something happens, someone's going to call 911. And,
right. Right. So. That's excellent. I mean, that is very, very powerful, because I'm sure in the course of life, these things occur rather frequently, where accidents happen that are catastrophic, or just a number of things. And without that bracelet or some kind of a written authorization, that could create a problem.
Yes, yes.
Wow. How does it, well, why should I ask, how does it play out? It plays out badly. Yeah. That's how it plays out.
What could happen to that person is they could have a heart attack in a restaurant, and even if their family might know, they panic, so they call, and emergency comes and they revive them, and that's not what they wanted. But, right.
Boy, that's amazing. Well, let us continue. Okay, so now we have the DNR as a component and parcel to that estate planning.
But remember, the DNR isn't really a legal document. That's really, it kind of goes along with the living will and healthcare power of attorney, and you talk with the doctor about it. So it's not really part of, I wouldn't call it part of estate planning in terms of what lawyers do.
Well, let me ask you a question on this subject of HIPAA, because I was very heavily involved. I'm a certified senior advisor, and I put a lot of time at one point in my career with nursing homes, understanding how nursing homes work. I did a lot of volunteer work with nursing homes, and one of the most disturbing things that happened to me often, because people do die in nursing homes, is a person that you would be working with, you'd come to their room and they're gone. And no one would tell you anything. And they would say to me, Michelle, we cannot violate HIPAA. And I don't mean to sidebar on this, but can you tell me why that happened?
Well, and see, what you want to do, if you have a family member or somebody in a hospital, nursing home, if they're still competent, what you want to say is, well, hey, can we have mom sign a HIPAA release for fill in whoever you want, family members or whatever, so we don't have that kind of problem.
Oh my goodness. So they aren't even allowed to tell you if a person dies under guidelines?
Yes.
Who gets that information? Those who are on that HIPAA release?
Whoever's on the release, or again, if the person's not competent, then whoever is named under the healthcare power of attorney.
Got it.
But that person could also, under the healthcare power of attorney, say, look, I want to sign a release so my sister and neighbor and so on can come in and see mom and at least call and ask what's going on.
Because that was one of the low points of my practice, which is you befriend elderly people, you love them. They're part of your world. And you come in to see them and they're gone. And nobody will tell you anything. It's like the person didn't even exist.
Yeah. Well, that's HIPAA. I know.
Oh, that's HIPAA. I don't like HIPAA.
And again, HIPAA has not only penalties, but also criminal penalties. So that's why
oh, no,
so
no.
they're
I got
very,
it.
they're very afraid of it.
Real.
Yeah.
So that has to deal, that is not a part of estate planning, but it is an aspect
Yes.
that needs to be looked at.
Yes.
I appreciate you giving me insight. I had no idea why. I just said, what is going on? Because everyone, they do get very, very nervous about that. And you say, but where can I, where?
Yeah.
Can't say anything, sorry,
Yeah.
can't say anything.
Yeah.
That is very, very uncomfortable.
Yeah.
I guess there's a reason.
Yeah.
Yeah. Okay, well, let's move on beyond HIPAA, because I'm getting a little bit
Okay.
uncomfortable about that. So what's next?
Well, the last aspect of estate planning is planning for long-term care.
Planning for long-term care.
Right.
Would you translate that to common man's language?
Another unpleasant thing we don't like to think about. We talked about people don't like to think about dying, and which is what estate planning is about planning for. But we don't like to think we would ever go to a nursing home. Nobody wants to go to a nursing home, and we all hope we don't. But the
stats are pretty compelling, though, Mike.
Oh, yeah. There's a 43% chance if you're over 65 that you'll spend some time in a nursing home. Maybe a few months, maybe many years, but that's a pretty compelling statistic. And I think there's a 10% chance people over 65 will spend 5 years or more in a nursing home. Those are pretty high statistics.
Well, and the numbers for women. See, that's my little group.
They're
women.
A little higher, yeah.
Oh, yeah. Women go to nursing homes and they stay a long time. Men go and they don't stay as long. But women do tend to stay, statistically at least, a considerable period of time. So let's talk about that as a part of estate planning.
You know, one of the things I say about estate planning in general is we plan for the worst and we hope for the best.
Yes, we all do.
We're not planning on going to a nursing home. But we might, and we're not planning on dying, but we know we'll die someday. So we plan for that, and then we forget about it and try to be positive about everything.
Right. Well, you have automobile insurance. You don't want to be in an automobile wreck.
Right.
But if it happens, you want to at least have covered that risk.
Right.
Okay.
Right. So there's really two ways to plan. The first best way is just to look into long-term care insurance. It's specific insurance that covers this event, and of course, I skipped over this, but Medicare generally does not pay for nursing homes. There's
Could you
limited
say that
coverage.
again? Because I hear this all the time.
Medicare does not pay for nursing homes. There's some limited coverage. If you go in, you might get 20 days, maybe up to 100. But in the long term, Medicare does not pay. Your Medicare supplement also does not pay. So you're
strictly for health. Medicare is for health.
Yeah, it's just doctor bills, hospital, but generally not for nursing home care.
Custodial care. Yeah.
Right. So long-term care insurance is the best thing to get. Now, the first thing I always hear is, people say, I hear it's expensive. Well, it doesn't cost anything to go talk to an agent. So
I couldn't agree more. I couldn't agree more.
And what I tell people, I don't want to give financial advice, which is really, that's more of a financial decision, but I tell people, get the best you can afford. So maybe you can't afford a 5-year policy that pays $200 a day. So maybe you can just afford a 2-year policy that pays $80 a day. It's better than nothing.
But you're aware that under the Pension Protection Act, seniors can now do an exchange of their annuity to buy a policy that will purchase long-term care insurance. And if they don't use the insurance, they can still get the money. Because that's a big issue, which is, how do I pay for this? And then secondly, what if I don't need it and I bought it? And so the industry has responded to that. There are policies available today that will allow them to cash value their life insurance as well as to do an annuity under a 1035.
Right, yes.
That is amazing. I think the government's trying to tell us something, Mike. I'm a baby boomer. I think they're trying to tell us something, which is you need to use your money to pay for your long-term care, because we're not.
Right, right.
Is that what your sense is, that the
Sure,
government's
sure.
getting out of this?
Yeah, the government wants to, I mean, Medicaid, which pays half of all nursing home bills, I didn't get to that yet. But
Okay,
Medicaid is a big burden on the government, so they want people to cover cover this in the private sector with their money. So, right.
And I'm not opposed to that. I think that as this becomes an increasing concern for families, because the elderly many times are not aware of what that puts their families under, the children, and trying to juggle taking care of mom and dad and raising their own families. That's a real emerging issue today. But I didn't want to get off track. I was listening to you talk about Medicare.
Yeah, okay, yeah. So,
okay.
So the first solution really is to look into long-term care insurance. The second solution is to look into some type of estate planning to protect your estate and become eligible for Medicaid. Now, we could talk about this for a whole hour, but I'll give
And
you
we
kind of
will.
an
Yeah,
Okay.
I'll bring you back to talk about that.
So the Medicaid program does cover nursing home bills. In fact, it pays half of all nursing home bills overall, so it's not unusual. And in Ohio, I'll just say specifically in Montgomery County, every nursing home in Montgomery County is Medicaid certified except for one. So it's
Really?
not unusual.
Okay.
Now, normally people think of, gee, why would I ever be on Medicaid? And Medicaid has all kinds of different programs, but in this particular area of long-term care, that's something that Medicaid covers. And if you don't do anything, what can happen is if you have no insurance, you go in there, you just spend all your money, and then you're down to $1,500, and then you're eligible for Medicaid.
Right.
So, and that's the basic rule.
Okay.
You're not eligible if you have any more than $1,500.
Is that for a couple or for an individual?
Well, that's kind of rule number one.
Okay.
So for a married couple, first of all, Medicaid looks at everything they own together. So it doesn't matter if your husband goes in the nursing home and the wife has everything in their name, doesn't matter. It's all lumped together. There's an additional allowance for the community spouse, which it's generally half, but there's a limit on that. And then the house is exempt if the community spouse is living there, and so on. There's lots. I can't go over all the details, but there's a lot more beyond that. So.
Well, that's for another show.
Yeah.
Because that's a big area, and seniors are, and rightfully so, seniors are very concerned about that, and I think they should be. I think they should be because, in your case in Montgomery County, there are many Medicaid certified facilities. A little further down south in Cincinnati, it's not the case. There are many facilities that will not accept individuals under that program. And the ones that do, the levels of care, even though there's not supposed to be any kind of a compromise, many times we found that the level of care is not the same for those who are up under that federally funded, state-funded program for custodial care.
I haven't really seen that here in this area.
Believe me, I know about you. I give you all 5 stars because I think that it's been an even-handed, balanced approach to care for the elderly up here. But as I said, I think that varies from county to county.
Yeah, that could be. My experience is that the people who are working there's no separate Medicaid area.
There is not.
And the people working there, the caregivers in the nursing homes, they don't know who's on Medicaid and who isn't.
They don't.
So it's the same care, really.
No, they don't. Yeah. But I will just say this, and my great uncle just passed, and he was at you can go and check the ratings of all of the facilities online. The state has inspection reports, and I advise all people to please avail yourself of those reports. But they've had severe cutbacks from funding.
Sure.
So a lot of their people are not, the staff have experienced reductions. And so the quality of care has changed. And while the facility accepts everyone, it is skewed toward those who are essentially Medicaid, and there has been some level of quality diminished because of those cutbacks by the state. because it is very hard to carry a full load if you don't have full paying people. So that's just a perspective I'm just bringing. So we're just shifting back. So the issue of Medicaid, if you're not going to do Medicaid, then you want to consider long-term care insurance.
Yeah, well, you consider that first.
First,
That's first.
okay, long-term care insurance.
Right.
And just bite the bullet, correct?
Well,
Meaning,
again, I say get whatever, at least talk to an agent, and I say just get the best you can afford, but at least look into it. Don't just listen to people saying, oh, it's too expensive. At least look into it.
right. And I would have to ditto that because the industry is shifting. And we're finding more and more products that are suitable for people to qualify for this product. It's a nice thing that's going on right now. It is. Okay, so where do we go?
One more thing on estate
Okay.
planning, it's important too, and the laws changed on this. I just gave a talk on this in front of some lawyers a couple weeks ago. It's planning for your funeral and burial. And the law used to be different, so I have a hard time convincing lawyers that we have a new law and that they need to pay attention to it. The law used to be that if you wrote out burial instructions, it's not enforceable. There was no law making that an enforceable document, and that the next of kin had the right to determine your burial and funeral. So if you pass away and you're married, and maybe it's a second marriage,
Yes.
or whatever your situation is, if you're married, your spouse has the right to decide everything about the funeral and where you're buried or cremated and so on, regardless of anything you might write out.
Really?
And you can imagine there could be situations can arise in a family where there's disputes,
Yes.
or there's second marriages, and so what happened in 2006, we had a new law put into effect, and it was actually sponsored by the funeral industry because they see a lot of problems. They're the ones that see these problems, and the law now says you can have a declaration doing two things. One, you appoint somebody like a power of attorney, but you appoint somebody under the new law who has authority to make all the funeral and burial arrangements. And then two, you can
Wow,
also
okay.
state your intentions or wishes.
Okay.
So,
And those are legally binding?
yes, yes,
That's significant.
yes. Yeah,
I
and
didn't know that.
Yeah, and the
That's
document,
significant.
the document's kind of interesting. It's, I don't like to use the legal terminology, but when I just call it a declaration for funeral and burial instructions, but technically the law calls it an assignment of rights of disposition.
An assignment
so-
of rights of disposition.
So,
Okay.
so I don't like
Okay.
that terminology, but that's what it is. But what I describe the document, it's more like a power of attorney. You're really appointing somebody who has the right to make all these decisions. And
On behalf of the decedent.
right, and that's really
Okay.
controlling. You can state your wishes, but it's really up to the person to make those decisions. And I'll just say, at first I kind of didn't like that. I kind of thought, why can't you put your wishes in there and have that be controlling? But then I've realized, you could put your wishes in there, and then a lot of things could change. Circumstances could change. You wanted to do an expensive funeral, but maybe you can't afford it now, or you wanted to be buried a certain place in Ohio, but now you're living in Florida. So it really is better to have that flexibility and to let that person make the final decision, I think.
Now, that is very interesting. And I have, again, that's new information. The law was 2006. This is 2012,
Yes,
Michael.
I know. I know.
So under that particular, the requirements of that document is that first you have to prepare, an attorney prepares that instrument. Okay.
Yes.
That's a part of the estate plan.
Yes.
You name a person who would handle your burial rights and et cetera, correct?
yes.
Now, can you have as an ancillary document personal instructions?
Yeah, no, that's included in there.
Oh, okay,
And when
because I do
draft-
personal
yeah,
instructions,
oh,
but
yeah,
I didn't know.
Yeah, it's in there, and I put it in there, and actually the law provides that if the person's wishes aren't being followed, somebody can file in court and contest that. So,
Really?
So it depends on what the person wants. Some people do have very definite ideas of what they want, and I draft that differently, and I just use different, more mandatory language. This is what I want, and that way, if for some reason the person doesn't follow that, someone could challenge that. But that
Right.
shows the importance of picking the right person to be that representative in that document or any other document. You want someone who's going to follow what you want.
That is
So-
very, very powerful. Do you have in the document any kind of language that says the budget, it cannot exceed X number of dollars?
You can.
You can?
Yeah, you can. Yeah,
Okay,
that's
so
in there.
that's allowable as well. Can you state in the document who you want to handle your funeralization?
Oh yeah, that's the important part of the document is naming. It's like the power of attorney. You name a
Okay.
representative who handles, who has authority under the law to make all the decisions.
Wow.
Yeah.
That's a very important document.
Yeah. You know, another interesting thing, this kind of gets back, in the very beginning we talked about legal forms.
Yes, yes.
The statute attaches a suggested form. It's not mandatory, it's just like a suggested form. There's one paragraph in there that, and it does say optional clause, but it says the person who's the representative signs and they say, I assume responsibility for the funeral home bill. Now, if I'm representing a client, there's no benefit to my client to do that.
Right.
So it just points out why these standard forms you find somewhere aren't always the best. I mean, that's obviously good for the funeral home.
Exactly. But how
but,
is
yeah.
it enforced? How do you enforce that?
Well, if someone signs it, it's enforceable. But,
Okay.
but my point is, I don't use that clause in my document.
Okay, right.
In other documents like it, there's also the healthcare power of attorney, living will. There's a very common form. It's not, official or required. There's a common form for those two documents that a lot of people use. It was drafted by a group of mostly Ohio Medical Society and other medical groups, and the Ohio Bar Association participated. People think it's an official form, but and it's okay. I'm not saying it's a
Okay.
bad form. But there's a few things in there that are just for the benefit, in my opinion, of the hospitals and so on.
Okay.
So they're not in my document.
Okay. Okay.
So, but I just want
Okay.
to bring that point that sometimes people think we have official forms, and there's nothing official about them, and there's things in there that the layperson wouldn't realize, gee, this isn't really to my benefit.
And should not sign. Should not sign. Or in many cases, I think you're kind of put in a position where you have to sign. Particularly
Yeah.
when it comes to nursing home admission. Many times someone has to sign as the financially responsible individual.
Yeah, and it's presented as an official
An
form.
official
but it's
form,
not.
but it is not. But it does have enforcement power,
Oh
correct?
yeah, it would be a legal form.
Yeah,
probably. Yeah, sure.
yeah.
Oh yeah.
Okay,
yeah.
that's what. Even though it's not official,
Yeah.
it can be used to enforce. That's
Right.
important. That is. So, may I ask a question related to that? If a person, with those directives in terms of the funeralization, under a typical life insurance contract, you name beneficiaries. Under and the funeral home is not named, but yet they can take an assignment.
Okay, yeah, you're getting to the prepaid funeral plan, right?
Yeah, I'm trying to
Yeah.
understand because I'm still not clear, and I'll be very open with you about it. Is there anything that protects the named beneficiaries? How do I say this? If a person has a $100,000 life contract and they expire, and they name their two children, but they've not made any kinds of arrangements or have an escrow to pay insurance, to pay the bill,
The funeral bill.
the funeral
Yeah,
bill,
right,
and the family goes and the funeral home says, don't worry about it because they've got insurance. But the insurance has two beneficiaries, the two children.
Yeah.
The funeral home says, well, the bill was $10,000, and typically the insurance company will pay them out of that insurance contract. Are you following
Well,
me?
they can if
Right.
those kids assign it to the funeral.
Right, if they
that can
assign
be
it.
done. Right, right.
How is there accountability? How does the family know, in fact, that the bill that was submitted was, in fact, the actual expenses?
Well, you have to get an itemized bill from the funeral home.
Okay.
And review that. But also, too, one of the things, a lot of times people have insurance and they say the kids will use this to pay the funeral bill.
Right, they do it all the
But
time.
if it's payable to the kids, they don't have to use it for the funeral. I'm not saying they won't.
Right, right.
But that doesn't, it's not a way of assuring that gets done.
Right,
So, yeah.
right. That is a concern because I will say on pro and con, getting money from people after parents are gone is one of that industry's real issues today.
Oh yeah, it sure is.
I mean,
yeah.
in Florida, in fact, the number of urns, unclaimed urns, because a funeral home will not dispose of ashes without someone from the family coming to get them.
Right.
And I was, this goes back some time, but he said that's a problem because they will not, they won't pay the bill and they will not collect the ashes.
Right.
So in a situation like that, how does the decedent at least know that that's going to be taken care of properly?
Well, I mean, there's a couple answers to that. But first of all, in their probate estate,
Okay.
the law has a list of priority of bills, and I think the funeral homes
It's
read
right up
number
there.
2.
Yes, yes.
And I can just tell you from experience, the probate court always makes sure the funeral home bill gets paid.
Okay.
So, but of course, the other thing you can do, you could do a prepaid funeral contract. You can arrange your own funeral ahead of time, or even the kids could, but you could arrange it yourself and pick what you want and pay it ahead of time, and that's a prepaid funeral contract. And the advantage of that is everything's done. So when mom passes away, you don't have 9 or 10 decisions to make on all the details. You just walk in and it's all done. So,
Well, I have to say very candidly, we just did one with my great uncle who passed at 91. And 2 years ago, we went on and just took money out of his bank account and just did everything. He was a veteran. He wanted certain flowers. He wanted his casket. All of these things were done in advance and paid, and there was a contract. And it was assignable, meaning if he didn't want to be that funeral home to handle it, it could be assignable. Now that is something the state of Ohio, I understand, has required those contracts be assignable.
oh yes, there's an Ohio statute governing these prepaid funeral contracts.
Okay.
And one of the provisions is, if you buy one of those and maybe you move to Florida or somewhere else, that can be assigned to another funeral home.
Okay.
So, yes,
okay.
yeah.
That's so even out of state.
Right.
Now, is there reciprocity with other states if a person pre-plans in, say, Texas, but winds up moving to Ohio? Is there a reciprocity agreement in place for something like that?
Well, if you bought a contract in Texas, it would be governed by whatever Texas law says.
Okay, so you really would have to know those kinds
Right.
of things. But in the state of Ohio, there is assignability.
Right. Right.
Outside of the state.
Or transferability.
Okay, yeah, I'm thinking of transferability. That's nice.
Now there's some disadvantages to the
Okay, well, let's
prepaid
talk
funeral plan,
about that too.
The disadvantages is you got to pay now.
Right, exactly.
Instead of later. Now sometimes, actually I'd say most of the time, because people don't want to write a check now, if they have life insurance, they'll assign it to the nursing home, their existing life insurance. So sometimes people do that. The other problem is that, the fact is there's just been lots of stories and things that have happened where funeral homes have gone out of business.
Yes.
And so on.
Yeah, because I was a little, I'm just telling you, I was a little nervous.
Those things do happen. Now, Ohio has really a pretty good statute. It protects that because if you have a prepaid funeral contract, if you pay cash, the money should be held in trust by a bank.
Okay.
Or if you have the life insurance, same thing. So it's protected. So we have a pretty good contract. But it could be the nursing, or I'm sorry, the funeral home got their money and never sent it where it's supposed to go. So it's not. There's no.
Do you have a
guarantees.
paper trail that can you request that
Well,
you get
yes, if somebody,
proof of deposit?
let's say you go buy a prepaid funeral plan and you put down cash, or you buy insurance, you are supposed to, under the statute, get a notice within so many days directly from either the bank or the insurance company that they have your money or contract.
Okay. Okay.
So if you don't get that, then you want to make a phone call.
Okay, I would definitely. So in a situation like that, would you call the funeral home or
Yeah, I would call the funeral home, because
first.
if you didn't get a notice, that means that's where
Something
it's-
is not
yeah.
kosher.
Yeah. And they could have just not sent the paperwork in, or I don't know what. But,
Yeah.
so you know, there's pros and cons of doing. And the other thing about the prepaid funeral plan, it's not enforceable. Remember, I talked about the declaration for funeral burial instructions.
Right.
Just because you have the prepaid plan doesn't mean someone has to file. So if you have a plan, but you pass away and maybe you got remarried or something, your spouse says, well, I don't want to do that. They don't have to file that. Now, the way you make it enforceable is you have the document I talked about, the declaration for funeral burial instructions, and you simply incorporate it and say, I want my prepaid plan followed by my representative. So.
Neat. Yeah. You know, that's what I appreciate about law. Even though it seems to be lots of layers, it's extremely important, because people are all over the place. And the lack of uniformity can create real problems.
Sure, sure.
So even with a prepaid, it does not necessarily mean it's enforceable.
Correct.
Oh my goodness. Where a person has already funded it, and their spouse, or if they they say, we don't want to do that. Yeah. But are there refunding clauses? Can that money be refunded?
Well, yeah. If you have a typical prepaid plan that's revocable, sure, you can get your money back. But a lot of times people do an irrevocable plan, and in a situation where you're spending down in a nursing home, you have to do an irrevocable plan.
Right.
So,
right.
Yeah.
And that's important. A lot of people don't know that if you are on Medicaid, you can have you can do the prepaid, but it has to be irrevocable.
Correct. Right.
You cannot have a change of mind and try to use that money, because that's not going to happen.
Right.
That's a no. That is a no-no. Well, you know, in the remaining minutes that we have left, hasn't this gone fine?
Sure, we've covered.
Yeah, we've covered a lot in a very limited period of time. What are some of your concluding thoughts as we wrap up your interview today?
Well, let's just summarize. The purpose of estate planning is to plan all your affairs to make things easy for your loved ones. We don't want to leave problems or litigation. We want everything to go smoothly the way you want. And your estate planning basically involves having a will, a general power of attorney or financial power of attorney, a health care power of attorney, a living will, a declaration for your funeral burial instructions, and some type of planning for long-term care, either ideally long-term care insurance, or some type of estate planning to protect your estate in terms of Medicaid eligibility. So that's kind of a summary there.
Well, I can say to those of you that are viewing, Attorney Mike Millonig is considered one of the state of Ohio's top super lawyers. The area of expertise is in estate planning, probate, and trusts. And I can tell you from my own personal experience, having worked with him, which is why I was so excited about having him to come onto the show, because he is truly extraordinary and exceptional in terms of his expertise. I would like to conclude by saying to all of you that are viewing that just like in the medical profession, there are generalists and then there are specialists. The same thing is true in the area of law, and even in my industry. But in the area of law, it is very important, and this is not to discredit attorneys who are general practitioners, but if there are issues that affect you in the area of estate planning, trust work, Medicaid, and dealing with nursing homes, then you need to deal with a certified elder law attorney. This is a specific designation through the Bar Association. Am I not correct? The American?
Well, there's two different ones. The National Academy of Elder Law, or Elder Law Foundation, is the elder law certification.
Right.
And then the Ohio Bar has an estate planning, trust, and probate certification. Yeah.
But it is extremely important that you do business with a specialist, a person who has actually prepared, had to go through exams, and for licensure. And because, again, this is such an area that is specialized, and you need to do business with those who are credentialed. So I would like to conclude today's segment of On the Money with, again, I'm delighted to be your host, Michelle Graves. I hope that you have enjoyed my time with Attorney Mike Millonig, whose offices and practice is in Dayton, Ohio. But again, he's known throughout the state of Ohio and nationally as well as one of the top attorneys. So I appreciate you listening in today. I look forward to you being a part of my world, and thank you, and God bless you today for being a part of Michelle Graves' Power of Money. You take care.